Okay. I hope we're all able to watch that video.
Okay, we're able to watch the video.
Hello, can you all hear?
Yes, tell me, I can hear you.
Okay, so were we able to watch that video?
Yes. I saw something, but I was not in the meeting for like a few seconds.
Okay. Okay, so I'm assuming that we're able to see the video. Now, what we've seen
Is a classic case of an industrial dispute. Okay, I'll call it trade dispute. They come with by different names: an industrial trade dispute, a trade dispute. I'm not sure if Tutu was able to catch that video, but I'm going to ask Tutu. Tutu is someone who has faced industrial action by a trade union before. And I just want to ask you, as a precursor to my presentation, on the day your company was picketed, you don't need to mention the name, but on the day your company was picketed, what was the mood like? How did you feel as an in-house counsel who had to deal with the situation?
I'm on mute.
Yes, you've been unmuted.
Oh, okay. Well, I think at first it was first confusion, but later it was. I mean, I think I was a bit disappointed that all the discussions or all the negotiations still led to this. There was a breakdown that caused this sort of action. I'm not sure if I've
Okay.
answered your question. I mean, I just joined, so I'm not sure what you were discussing before I joined.
Yes, we just showed a video of the picketing of MTN's office by
Okay.
NLC, which happened recently. And I was
Mm-hmm.
asking if there was anybody who had faced that situation personally, which was why I picked on you, because I know you faced that kind of situation. But before that day, before the picketing and the action by the industrial action by the union, did you take any legal steps to apprehend that situation? And if so, did those steps work
Oh
on that
no,
day?
nothing worked. So I mean, I don't know what you mean by legal steps. So they're the normal steps that you take. You engage the ministry. You try to discuss with them. So those were the things we tried to do. But we also we knew that we were going to go ahead, irrespective of whether we're able to reach an agreement on that day or not. So we had sort of put together a contingency plan, and part of that was that okay, we're going to have security in place. We're going to try to get an injunction quickly. We're going to engage the police and all of that. But nothing worked. You know, they still did it successfully for 2 days before anything kicked in. Because I mean, the injunction we didn't get a hearing date early. The police, the police were there to sort of contain it, but what you also didn't want was you didn't want a face off between the police and the protesters, because my concern was if there was a fight between the two, if somebody happened to die, everybody will forget union and police. Will be this company and its union were having an issue, and then three people died in the midst of it. So would the name of the company would be smeared. So we also asked the police to just keep a respectable distance. So nothing worked. They did what they wanted to do. At first, we had thought that because we didn't occupy the building solely, they wouldn't, they would just sort of contain themselves as much as possible and allow others enter. But by the second day, they didn't allow any other person enter the building. So all the offices in that area couldn't work as well. So it was a mess.
Hmm. And how was it resolved eventually?
We went to the ministry. So I went to the ministry. I went to beg the ministry that can they please, yes, we didn't listen to them when they asked us not to do it, but that can they please intercede? Can they come to these people and come and talk to them? So they did that first one, but they weren't able to get the unions to stop. So the next day, we then went to the police. So the commissioner of police then summoned all of us. The third day, summoned all the two parties. So it was at that point that the commissioner of police then threatened them and said to them that, look, I have no problem with you picketing this company on its own, but if you affect other people, then you have exceeded your powers. Yeah, it's now an unlawful picket. And he sort of issued a few threats, and I think that that's what brought them, that closed it for them. So I mean,
Okay.
they still didn't allow us to open our offices. They will still come every day and ensure that our office premises were locked. But at least they allowed the other um, companies. They allowed the other companies to operate to enter the building. Yes.
I see. Okay. Thank you for sharing your experience, Tutu.
You're
And
welcome.
what you said buttresses what I mentioned before you joined, that dealing with unions is very, very tricky for lawyers and for companies all over the spectrum of the sector of the economy, because the weapons to address in dealing with unions, uh, they are not written anywhere in any book, trust me. And at the end of this presentation, we would be cross fertilizing ideas on how best to tackle unions from those who have had some experience on that issue. So, but then let's just start at least with what's in the books by discussing what a trade union is. And if you look at the Trade Unions Act, which is the principal legislation regulating trade union, you'll see that definition in section 1, where a trade union is defined as any combination of workers or employers, whether temporary or permanent, the purpose of which is to regulate the terms and conditions of employment of workers, whether the combination in question would or would not, apart from the act, be an unlawful combination by reason of any of its purposes being in restraint of trade, and whether its purposes do or do not include the provision of benefits for its members. Now, loaded in this singular section of the Trade Unions Act is a whole lot of jurisprudential issues, which makes trade unions very, very powerful. Powerful in the sense that both by this section and by many other sections within the gamut of the Trade Unions Act, you get to experience the immense power that the law has granted to trade unions. I won't even go into the historical background of how trade unions came to be and why the law deliberately made them that powerful. But to summarize, it all comes down to that assumption that workers have lower bargaining power than their employers, and it is therefore necessary to protect employees and give them some semblance of strength to deal with employers to get a fair bargain in the contract of employment. But what one or two things I would like to point out from this definition is that number one, a trade union does not have to be a union of workers alone. And many people don't realize that just as the workers in an industry or in a company can form a trade union, so also are the employers permitted by law to come together to form a trade union. Now, that is not common, but the common example we have around is of an employer's trade union is the association called NECA, Nigerian or is it National Employers Consultative Assembly or Association. I'm not sure which. So, but that is the only employers trade union that I am aware of, and I won't go into that. But I wonder whether to call NECA a trade union or just an association or a pressure group, because it's not even one of the trade unions contained in the schedule to the Trade Unions Act. So, but the second issue I would also like to point out is that trade unions are allowed to have as part of their objective restraint of trade. Restraint of trade is a technical term in employment and labor law, which means interference with the business or economic interest of a person. So ordinarily, if you come to my premises and you poach my employees, or you, as an employer, tell your employees that after you leave my employment, you cannot work or practice this same trade with me for 3 years. All of those are contracts or agreements in restraint of trade, and they are generally unlawful, except you can justify them under the conditions set under the law. So, but what you have here in this section 1 is that the law is saying that when a group of workers come together, they can, it is not unlawful if they set out from the beginning to restrain the trade of other people. And it goes further to even say that it doesn't matter whether their purpose is for the benefit of its members or not. I find this last part very interesting because it would seem to contradict another section of the Act, which, if I remember, I'll point out later on in this presentation. But that's what we have as the definition of a trade union. Now, how do you form trade unions? How are trade unions formed, and how are trade unions formed, and who can be members, who can be a member of a trade union? And of course, the first thing to note is that a trade union must be registered, just like you have companies registered before they can get legal personality. A trade union must be registered with the registrar of trade unions. And the other issue to note, which I know a lot of employers don't like to hear, is that membership of a trade union by employees is voluntary, and you cannot stop someone from joining a union or force someone to join any trade union. So we've had cases where an employer will say, "Oh, I don't allow union in my premises," or they will say, "Okay, I allow union, but it is only this union I want you to join. I don't like Pengasan because they are troublesome. I have friends in Nupeng, so it is Nupeng that all my employees can join." That is not allowed because it negates the principle of voluntariness of membership of trade unions and the freedom of association under our constitution. Now, there's also this jurisprudential question about um, the extent of the voluntariness of trade union membership. Now, under trade union law, there's something called the contracting out system. And to summarize it, what this simply means is this: the law has now created two different scenarios when it comes to membership of trade unions. When it comes to junior workers in a company, junior workers meaning people who are not in the who are not a projection of management. We'll get into that shortly. For the junior workers, the manual workers, your laborers, your clerks, those who are on the lower rung that ordinarily the Labor Act would apply to. What the NIC is saying is that those people are automatically members of a trade union that operates within their industry. Now, what that means is that if I join your company as a gardener, I do not need to write you a letter or give you notice of my membership of a trade union. I am automatically a member unless I write you a letter stating otherwise. That is called contracting out. So the contracting out system means that for anybody to be deemed not to be a member of a union, that person must write a letter or give a notice to the employer that I am not a member of any union or I'm not a member of this union. Therefore, do not deduct trade union dues, usually called check-off dues, from my salary. Because if that is not done, what the law says is that, or what well, I won't say what the law says because I disagree with it. What the NIC says is that um, if you're a junior worker, you're automatically a member of the relevant trade union, and check-off dues should be deducted from your salary and paid to the union. However, if you write or give notice to your employer that you do not wish to join, then you will be exempt from that arrangement. But the very opposite is what you now have with respect to senior staff. And then I said, for senior members of staff, they are not automatic members. They have to contract in. They have to write or give notice that I would like to be a member of a union before you can start deducting check-off dues from their salaries to the union. And I personally find that interesting and hard to agree with because definitely when it comes to voluntariness, freedom of association and all of that, I think it only stands to reason that no one can be forced to be members of a union. So to say that someone is automatically a member of a trade union, for me, does not do justice or violates that provision of the Constitution. But the reasoning behind that position of the National Industrial Court is that junior workers are perceived to be in um, in in an unequal bargaining power position, so to speak. They are vulnerable. That's the word used. That junior workers are vulnerable. They are not able to step up to their management and say, "I want to join this trade union," unlike senior members. Whether that is true or not, I think is a discussion for another day or maybe during question time. But that is my own position. I do not think it is correct. I do not think it is the intention of that provision of the Labor Act. But the current position of case law as it is that junior workers can only contract out. They are automatic members, while senior staff members need to contract in. They need to give notice that they want to be members of a trade union before you can deduct check-off dues from their salaries. There's a case of Nest Oil versus Nupeng that I cited on that screen, a 2014 case. And what happened in that case also goes to underscore the voluntariness of trade union membership. Because in that case, you had Nest Oil, which was an employer, suing Nupeng to say Nupeng cannot unionize our workers. And Nupeng filed a preliminary objection to say, oh, hold on. What is your business with whether I am unionizing your workers or not? Let the workers themselves tell us whether they want to join us or not. You are a busybody for coming to court to stop us from unionizing people in your premises. Nest Oil's argument was that, oh, if you come to unionize people that are not supposed to be in your union and there's an altercation or fracas over the situation, then it is going to disrupt my business. And we've seen many companies taking that step to say, oh, these unions are just going to come up and cause crisis in my premises. I have to go to court to restrain them, to stop them from coming to my premises. I am not an oil company. I am an oil servicing company or an oil consultant. I'm a consultant advising an oil company. Why is NUPEN coming into my premises? And then they go to court. But in every of those cases, what we've seen is that the courts have always thrown out those suits because the court's position is that the only person that can come to court to complain about either being forced to join a member or getting out of a union or suing a trade union must be the worker itself or the workers themselves. And therefore, the employer does not have any right, any standing in law to file such an action. And that's that about that. The other issues we need to pay attention to when we're advising on formation and membership of trade unions is that where there is already a union representing workers in a place that there's already a union, then um, no trade union will be registered by the registrar of trade unions. Again, the question here would be who then has the right to go to court to challenge a new union being registered, excuse me, in a place where there's already a trade union for that trade. Again, it is only a rival union that is already in existence that can take up that action and not the company that may be affected. That is the situation we have with the state of the law. Then there's also a recurrent issue that I have seen in practice that clients have sought opinions for every now and then repeatedly, which is what cadre of their staff are able or permitted by law to join trade unions. Now, this question becomes relevant because of a provision in the Trade Unions Act, which provides that no staff that is recognized as a projection of management within the management structure of any organization is allowed to be a member of or hold office in the trade union if that membership will lead to a conflict of interest on the part of that person. Now, let me just break this down as simply as possible. This is what it is. You are in a company. In your company, you of course you have your senior staff. In fact, above the senior staff, you have the management staff, your MD, your director of legal services, your legal advisor, your chief finance officer, your human resource manager, and all of that, or gas in the organization. Then you also have I don't want them to call them ordinary staff, but the non-senior staff, so to speak. Now, what this provision of the Trade Unions Act is trying to prevent is this: trade union activism or trade union issues are between the workers and the employers. And who are the employers? Who represent the employers? It is the management staff. If a union wants to make a demand for increase in salary, for instance, they make the request from the management of the company, right? And of course, the management of the company would either be the HR manager, the MD himself, and all of that. The law has preempted a situation where is it possible for the MD of a company that is going to decide on the request of a trade union to also be a member of that trade union? Or let me give you another scenario. You are the legal advisor of a company. You are also a member of a trade union. The trade union is making a demand that they want salaries to be increased from 100,000 to 500,000. And it is still your job as a legal advisor to advise that same company whether the demand of the trade union is legitimate or not. I think it is a no-brainer for us to realize that a clear conflict of interest has arisen there. Because in one breath, the legal advisor or whichever staff is involved is meant to protect the interests of the company by giving proper advice and probably researching the law and brainstorming with the management on how they can outsmart the union. But in another breath, the same person is also a member of that trade union who needs that increase in salary. So it is practically impossible or difficult for that same person to discharge that obligation without leaning towards one side. So it's always an issue of, do I love the company more or do I love my personal interest or the union more? So which is why the Labor Act has made this prohibition to say that once you are part of management, once you're part of the decision makers in a company, you cannot be a member of a trade union because you'll be conflicted in your duties. And it's as simple as that. So, but then the issue most employers have is then identifying who is a projection of management within the meaning of that provision of the Trade Unions Act. And how I always advise my clients is that it's simple. The test to be adopted is anybody who stands in a position of confidence, is it to or with the company. So if such a person is in possession of trade secrets or confidential sensitive information of the company, especially with respect to the trade union, then that person cannot be a member of trade union. So for instance, someone who is in custody of all the financial statements, data, and information about the company, for instance, cannot be a member of a union. So that if trade union say we want 100,000, and the company says, oh, we can't afford 100,000, our revenue this year fell by 20%, you go and tell the comrade in the NLC, it's a lie. We made 100% profit today. Ask, in fact, increase that 100,000 you're asking for. They can pay 300,000. It doesn't make sense. So the dichotomy is anybody who is in the decision making echelon of a company cannot be a member of the trade union. And it's merely a question of fact. Like I advised a client, it is not a question of the title they put. So many people are senior manager on paper, and the secretary to the MD, who is well packaged and all, makes decision more than the manager. So the fact that she's a mere secretary or PA on paper doesn't mean that she's not higher than the so-called manager in tie and suit. So it's a question of fact, and it also depends on the organogram and the corporate structure of each organization. Okay, now recognition of trade unions. Um, Under Section 25 of the Trade Unions Act, recognition of trade unions is automatic. This is another contentious area for most employers. Most employers always believe that because it is their company, they can dictate everything that happens there. So they can decide, just like they decide when you resume and when you close, they can also decide which unions can operate within their premises. Hey, thanks, lousy guys, we don't like them. We can consider these people, blah, blah, blah. Guess what? I hate to break it to you. Nobody, no employer has a right to deny a trade union recognition on its premises. How it works in practice is the union writes you as a matter of courtesy to say, we are coming to your premises, we have people who wish to belong to our union, and we are coming to enlist them. At that point, that is not a request to you to say, oh, please, can we come and unionize your people or not? No, you do not even have that right to decide whether they can unionize your staff or not. So Section 25 tells you that trade union recognition is automatic. Once that trade union is registered under the law and they come into your premises, and there are people who are willing and ready to join them, you can only say, hey, welcome, just conduct yourself orderly. It's not the nicest thing employers want to hear, but that is the position of the law. I always tell people that the only thing you can ask from such people is, where is your trade union certificate? Where is your evidence of registration as a trade union? If they can't provide that, then you have a ground to deny them access. Otherwise, just join them and hope that you can manage them as best as you can. Then, when the union have managed to come into your premises, God help you, or into your company, the law then expects that you begin to interact with them. Interact with them means that you need to start negotiating. Of course, when there's a union, anybody who's dealt with them will tell you that's the beginning of serious negotiation and conflict management within the company. And usually, the first thing a union would push for when they join, when they get into a company, is the signing of a collective bargaining agreement with the company. Now, a collective agreement is any agreement in writing which provides for the settlement of disputes and the conditions of employment of the union's members within the company generally. And how it works in practice is, don't forget that when the union comes into your premises, they enlist members who want to join them. Now, amongst those who join them, they then select, one or a few of them to be the representatives of that union in that company. So it's sort of like a mini exco within the company. Most companies prefer to see them as moles within the company, but then what can you do? If you sack them, you are in trouble. And so definitely, you see that there suddenly are two MDs within the company. There's the MD of the company itself. Then there's the I don't know what they call them. There's the branch chairman of the union within the premises. Is an MD on his own. And if you follow the crisis, I think it was Globalcom or one company had with a union then. I mean, it's pathetic where a union would insist that a certain management staff should be sacked, otherwise the company will be made ungovernable, and they always get away with it most times. And that's how powerful these special employees are, because by that time they're not longer ordinary employees. You can't treat them like the others, otherwise they will get your companies shut down. So usually the employer and the trade union reps would come together, form a body within the company to negotiate terms of employment of the workers within that company. So many issues about salaries, time of work, overtime pay, systematic increase in salary after a number of years, leave, everything that you can think of, they negotiate on behalf of the employees as a group. And I think that is really the intention of the law, of trade union law. Trade union law seeks to create a system where the employees as a whole can stand up to the employer and say, Oga, Alpha, this is 2 years since our people joined you. It's time for an increase. That is very difficult for an individual employer to go up to his employer and say, oh, I want a raise, or I am not happy with the hours of work, change it. It's always very hard. So, but collectively, they can hide behind the union to demand for things that they will not be able to do individually. And the belief, the legal idea behind that is that employees can get a better bargain for themselves under this system. And that documented agreement, which is the collective bargaining agreement, is a contract between every employee that is a member of that union that signed the agreement, and on one side, and the company itself on the other side. So it's an enforceable agreement. It's an agreement that can be enforced in court. I already mentioned this. These are issues that can that you find in a issue related to sick leave, redundancy, health, death benefits, um, and all of that. And but I also made a note there that irrespective of all the things that you can put in your collective bargaining agreement, at the end of the day, it is still not your, to put it crudely, it is still not your father's company. So trade union law reserves some issues that are exclusively within the right of the employer to decide on. So issues relating to promotion, transfer discipline, and technical issues about the company's operation is a matter for the company itself. It's not something that the union can say, for instance, when they say, all the we've been producing, I mean, we are into manufacturing, for instance, for a while. It seems this thing is no longer moving. Let us switch over to another line of business. Let us start doing entertainment. Bring the video and let him perform, and we'll make more money. Well, we think food is what is moving now. Let's drop plastic and let's go into food production. If you don't agree, we'll go on strike. That is not allowed. That is the sole prerogative of the company to decide on. And then the union can, for instance, also say, this is the person you must promote. This is the person you can't promote. I'm not saying, I'm sure many of you will be smiling inwardly. I'm aware that some unions, try to do this. They try to interfere in especially disciplinary issues. This person cannot be sacked. This person must be sacked. This person cannot go on redundancy. This one must go on redundancy. All of that is not right, at least according to trade union law, because the law only aims to improve your right, your chances of bargaining on the terms of employment. They do not give the union the right to then take over the company and start dictating what should be done, especially when it doesn't affect their members generally. And of course, I also mentioned this generally, previously, uh, that is enforcement of collective bargaining agreement. And we said that collective agreements are generally not enforceable unless they are incorporated into an employee's contract of employment or they are incorporated by statute. They are incorporated into an employee's contract of employment, if you ask me, in two ways. Um, in the contract of employment, it can be stated there expressly that, oh, this your contract shall also be construed or shall also be affected by the collective bargaining agreement entered into with the union from time to time, something along that line. Or in the collective bargaining agreement itself, there's usually a clause that will say this agreement applies to all ex, cadre of staff that are within the company as at this date, or all cadre of staff that are a member of this union at for any period of time this agreement is in place. So that happened. For the second means of incorporation, um, it is a procedure stated in the Trade Dispute Act, where it says that when you uh, sign your collective bargaining agreement, you should deposit some copies with the Minister of Labor and Productivity, who can then order to say, these are the people it will apply to, or these are the people it won't apply to. I haven't seen that in practice, so I really can't speak to that, whether it operates along that line. Now, what is a trade dispute? Just before this session, I was reading one recent case on the National Industrial Court website to prepare me for this presentation, and it was on the definition of a trade dispute. Now, what happened in that case was Keke Marua, we call it Keke Marua in Lagos, tricycle operators who came together to form an association. And then I guess they were having issues with the road transport workers union, which is a union recognized under the Trade Unions Act. And I guess those ones were trying to get them to pay some levies and all of that. And then they went to court. That's the tricycle operators went to court, challenged that levy, and said they were not bound to recognize the trade union, the Road Transport Workers Association. And interestingly, there was an objection by the trade union to say, you guys are not even a trade union. So it's not a trade dispute we're dealing with. It shouldn't come, to the National Industrial Court. And what the court said in dealing with the issue is, going by the definition of a trade dispute under the Trade Disputes Act, for a trade dispute to come, for a matter resembling a trade dispute to be such that can come under the jurisdiction of the National Industrial Court, it has to be a dispute between employers and workers, or between workers and workers, which is connected with the employment or non-employment and physical conditions of work of any person. Now, let's simplify this. What it is saying is this: the association of Keke Marua operators have an issue with a union that is trying to levy them. That levy, does it have anything to do with the employment of anybody? No. Does it have anything to do with non-employment of anybody? No. Does it have to do with the physical conditions of work of any person? No. Is it a dispute between workers and workers? No. Is it a dispute between employers and workers? No. So the mere fact that two unions are fighting over something does not mean it is a trade dispute. Although in that case, the court even found that even this Keke Marua association is not a trade union within the meaning of the Trade Unions Act, because it's not registered by the by the Registrar of Trade Unions. It's only an incorporated trustee registered with CAC. And one other tip that you also need to have in mind is for you to quickly know if a body that has approached you saying it's a trade union, and there are so many of them everywhere now. Hairdressers have a association, barbers have association. Which one have I seen again? So many funny groups coming together, and they say Okada, and all of them. So, but when it comes to trade union within the technical sense of the term, these are bodies that have been given legal personality by a law, which is the Trade Unions Act. If you pick up your Trade Unions Act and you look at the second or third schedule, you will see a list of all recognized trade unions there. Your NUPEN, Pengasan, Maritime Workers Union, and all of them, they are all listed there. So once anybody is not on that list, you are not a recognized trade union. However, the only caveat is that, of course, after that law was established, many more unions have been registered by the Registrar of Trade Unions. And of course, the law won't be updated every time just because one union has been registered. But most of the major trade unions, recognized trade unions, have since been, long registered. So you find them in that schedule. And of course, if you recall what we said earlier about the fact that the law won't even register you if there's already a union in your scope of your area of operation. So nobody, like one of my friends, is saying, was telling me that a group of law lecturers or young law lecturers have formed their own group, Association of, can't remember what they call themselves, Association of Law Lecturers or something, when there's already ASU. They can only continue as a private association. The Registrar of Trade Unions will never register them because ASU has already been recognized as a trade union representing the interests of lecturers in Nigeria. So it is always safe for you to refer to the schedule to the Trade Unions Act and be able to cross-check whether this union that has approached you is a recognized trade union under the law. And if you can't find anything, well, sorry, sir, I can't find your name on this list. It's possible you were registered after the law was enacted. Where is your certificate of registration? If they can't show you, please disregard them. Next, we should talk about the issues that can lead to a trade dispute.
When you have all your documents, then you can say, okay, I have only 6 months. But before then, you need to scout and all that. So time, and you know, age is going. Age is going. Me, I'm already 37 now.
Hello. Okay. Sorry about that. I think someone. Okay. I think someone unmuted herself inadvertently, and I think we have some other issues there. But let's continue. We already spoke about the issues relating to that could lead to a trade dispute. So I won't go into that again for reason of time. Now, this is another interesting part of trade union law on what kind of issues can give a trade union the right to declare an industrial action. The act was amended to provide that only disputes of rights are a valid reason for an industrial action. Now, let me give you some historical background to this issue for those of us who can still remember, because sometimes it's always easier to understand provisions in the context of the situation at the time they were enacted. In 2005, President Olusegun Obasanjo was the president, head of state of the Federal Republic of Nigeria. And in that year, there was one of the most crippling strikes we ever witnessed in Nigeria in recent history, or maybe for as far back as you can remember. That was a strike led by then Comrade Adams Oshiomhole over increase in fuel price. That strike was the mother of all strikes, and the government was forced to a standstill to the point that I can't remember exactly how it all ended, but if I remember correctly, it took, yes, so there are a number of things that happened then. At the end of the day, I think maybe the National Assembly intervened or not. But the effectiveness of that strike and how crippling it was led the government to amend the Trade Unions Act, right? Now, don't forget that we said the principal reason that the law came up with the idea of trade union is to enhance the bargaining power of its members. And that when you talk about the trade dispute, it has to be something relating to your conditions of work, employment, and all of that. Now, in that 2005 strike, what the NLC was fighting for was fuel strike. And the government's reaction was, hey, wait a minute. You are a trade union. You are meant to fight for your members. What is your business with the price we are selling petrol? In fact, President Obasanjo said, I'm the president of the country. You are president of a union. You cannot take over my job and start dictating how much we should sell fuel price. So what you guys are doing is nonsense. It is unlawful because you have become political. In fact, my political enemies are using you against me. This is not a labor matter. Face the issue of employment or terms of employment of your members and do not enter into politics. Because what you're delving into now is politics. Why are you striking over the price of fuel? It has nothing to do with your contract of employment. And of course, the NLC's response was that, oh, if fuel prices increase, definitely it will affect our members indirectly and all of that. So that was when government began to say that, oh, is the union getting too political? So what did the President Obasanjo do? He amended the Trade Unions Act. First thing he did was to break the monopoly of the NLC by saying that the NLC shall no longer be the sole federation of labor unions in Nigeria. Don't forget that when it comes to trade unions, the structure is also like the structure of the country. It's a federation or trade union. You have a trade union representing the oil workers, Nupeng, Pengasan. You have the one for the health workers, Mehun, or what do they call themselves? You have the one for the oil industry. You have the one for telecoms workers. You have the one for furniture workers and all of that. All of them collectively are under the umbrella of NLC as the apex body. So it's like your 36 states and the federal government. So in this case, you have your number of unions under the leadership of the NLC at the top. So what the government did then in 2005, they said, look, you guys, NLC, you are too political. Let us break your monopoly. They then amended the law to say that any other group of unions can also form once they reach. I can't recall the number now. They can also form a federation of trade unions, which was why in 2005 we then had the Trade Union Congress as another federation of trade unions apart from the NLC. So what the government was able to achieve by that deft move was that sometimes the NLC will declare a strike, TUC will say we are not going on strike. The ranks of labor was broken. And the second other thing they did was to amend the law to say that only any dispute arising from negotiation, application, blah, 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 of your contract of employment or collective agreement will entitle you or give you a right to declare an industrial action. So you can no longer say, we are going on strike because Buhari is going for second term, or we are going for strike because PDP was rigged out of the Osun election. The question would be, what are you fighting for? Are you fighting for your members, or are you turning yourself into a political party? So there's a dispute of rights, there's dispute of interest. Dispute of rights is lawful. I have a right under this contract to this salary to live to a fair condition of employment, and on that basis you can go to court, claim that right, or declare a strike to get redress, just as you have this current one about the minimum wage. But when you go to dispute of interest, and you're not talking about second term and politics and government policies and all of that, then it becomes a dispute of interest, which the law now prohibits. The lines can be blurred sometimes, and but that is the position of the law at the moment. Now let's talk about the legality of strikes. We have a strike going on right now, but there are also a number of issues we need to know when it comes to strike. And the first thing we need to know is that there's a procedure for declaring a strike. In our labor law group, we had the argument about whether it was right for labor to have declared this present strike, and my position was simple, which is that the procedure for declaring strikes has been complied with. Many lay people don't know, and that is the job of that's our job as lawyers and labor law lawyers especially, to let them know that labor does not declare a strike overnight. Nobody wakes up and say we're declaring a strike. There is a procedure for declaring a strike. The first thing is that before you go on strike, you must comply with the procedure in Section 4 or 6 of the Trade Disputes Act. Now, what is in, although I don't have it here, what is in Section 4 and 6 of the Trade Disputes Act is a mandatory arbitration, arbitration procedure with the ministry, with the Minister of Labor. So you must table the dispute with the ministry to, see if that can be resolved amicably. Of course, we know that the union has been in talks with the Minister of Labor, Senator Chris Ngige, for a while on the minimum wage issue. I think maybe upwards of 2 years they've been on it. So that is the first procedure that you have to comply with. You have to go through a conciliator, which is provided for under Section 8. If that doesn't work, you go to the industrial arbitration panel. If that doesn't work, or an award has been rendered by the IAP and either party is not complying, then the dispute should be referred to the National Industrial Court. So that is the procedure. And even before you go on that strike, you must then issue your 14-day notice to let the counterparty know that you are going on strike. Now, there's also the issue, another thing that was done in 2005 by the Obasanjo administration in amending trade union law was to bar a category of workers from embarking on strike action by saying that if you're a worker and you're in essential services, you are barred from embarking on strike action. And for those class of workers, they must go through arbitration and ultimately through the National Industrial Court. Whether that is complied with in practice or not, of course, is another issue. But then, need I tell you why these provisions are not complied with? You only need to look at the punishment for the contravention of the condition. The punishment is a fine of 10,000 naira, 6 months imprisonment. That doesn't deter anybody. This is also another contentious area. What is the definition of essential services? If you look at Section 7 of the Trade Dispute Essential Services Act, you will see a very wide definition of what constitutes essential services. Because of time, I won't read them in detail, but if you look at it critically, you see that it is so wide as to cover virtually everything. So if you are in the public service of the federation and you're employed in any industry or undertaking corporate or incorporate, the essential service. If you are established for supply of electricity, power, water, fuel of any kind, essential services. My question is, your filling station and all of that, won't they fall under essential services? If you are engaged in sound broadcasting, postal, telegraph, cable, wireless, telephone communication, meaning your Glo, MTN, Airtel, and all of that would fall under essential services, I guess. If you're engaged in maintaining the ports, the airports, and all of that, movement of goods by road, rail, sea, air, you are bad. If you are, even if you are, if you look at the last one, very funny. If you are engaged in the burial of the dead, hospitals, treatment of sick people, blah, 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 and generally public health matters, you are barred from going on strike. So what that means, and then you see a continuation, all the other essential services identified: central bank, printing and minting company, dealing with outbreaks of fire, and anybody carrying on banking business under the Banking and Banks and Other Financial Institutions Act. All of these people are barred from going on strike because they are deemed to be on essential services. And my question is it possible for you not to fall under any of these headings? I asked myself, and a question, an answer just popped into my head. I would say maybe lawyers, only lawyers will be working because we are not in essential services. So maybe we are the only ones that can go on strike, but we haven't go on strike anyway. So you have that. Now, because the industrial court has, sorry, because the industrial court now realizes the fact that with this wide definition of essential services, it will be practically impossible for any strike action to be justified under that provision. The National Industrial Court has come up with a very ingenious definition or interpretation to the concept of essential services. So, in summary, what the industrial court has now said in this aero contractors case is that it is not enough for you to say that these people are doing this type of work. You must show that the interruption of that work will endanger the life, personal safety, or health of the population. What happened in the aero contractors case very quickly is that pilots wanted to go on strike. Excuse me. Air pilots wanted to go on strike, and aero contractors went to court and said, "Oh, these guys can't go on strike because they are engaged in essential services. Court should restrain them." And the court said, "We won't restrain them because if they go on strike, who is going to die?" So it's not enough for you to say under Section 7 of the Trade Dispute Essential Services Act that they are engaged in transportation of people by air. You have to go further. You have to show how people will die if these people go on strike. And in that particular case, they even restricted it for us to say it's only the people who are working in air traffic control, air tower control, that long thing at the airport. Those people who regulate how planes land and take off. Those are the only people who are on essential service. If you are carrying luggage, checking baggage, how many kg does it weigh? Take tickets, collect tickets, move people into the plane. There's nothing essential about that. If they don't do it for you, the passengers will do it themselves. So those ones are not, you can't bar them from going on strike. So that is the way in which the law has, the industrial court has sought to ameliorate that provision. Now, let's quickly go into settlement of trade disputes. The mechanisms for settling trade disputes, of course, is contained in the Trade Dispute Act. I already made some reference to that when I was talking about the procedure for going on strike. Those are the mandatory provisions you will have in your Section 4 and 6 of the Trade Dispute Act. What you have in Section 4 says that if you have any agreement between yourself for settlement of trade dispute, then you should first attempt to settle it by that means. So if you have a collective bargaining agreement, for instance, that provides for arbitration or says that it's senior management of the union and the employer should meet before any strike is declared, then you must show that you have complied with that first before you do it, before you then go into these other things, mediation, conciliation, compulsory arbitration, and then the National Industrial Court. And oh, good enough. I've run through my slides faster than I thought. And one last word for me is what I started with at the beginning, which is that as lawyers, we are about one of the most important when it comes to dealing with trade unions, because I cannot count the number of times colleagues in-house have called me to and then another guy say, "Oh, we have a problem with it. Can you help us get an injunction? What can we do to stop them from?" And I said, "Look, let me not lie to you. Number one, it will be just like people said, it is very hard for us to rush to court to get an injunction at this time. But even if we get that injunction, we are not able to assure you that you can enforce it against a union because of the way they operate. They operate with impunity. They operate without regard for the law most times. And when they cause disruption to your business, you mostly cannot even pinpoint and hold anyone responsible. So my advice for people dealing with trade unions has always been that you should be more proactive than reactive, in the sense that you should constantly engage with your union counterparts. If you have sincere communication and you respect the agreement you enter into with them, then you will be better off than if you maintain a militant stance against them. And I've seen this play over and over again. I have a friend who uh, had this union come into their company, and when they came, they knew that they're going to have issues because the guy who was representative of the government, I mean of the union in the company, was quite troublesome. But then they also knew his weakness. So what they did was, Mr. ABC, congratulations on this your elevation as we are looking forward to work with you. But we're just looking at it. With this your new status, you don't think you should even be in the Nigerian office anymore. I mean, you are due overripe for a promotion, and we are thinking of moving you to the Amsterdam office, so that you can, of course, with the extra code and the better benefit and all of that. And of course, the man, after discussing it, I'm sure after discussing it with his wife and looking at the package, they say, it's a once in a lifetime opportunity. And of course, they took the offer, they moved him out of the arena of conflict and made sure that after 2-3 years, he suddenly lost his job. So, and that's why I said sometimes it's more street sense, but more importantly, you need to be sincere. Employee-employer relationship is not a master-servant relationship as we used to be taught then. If you are a company and you have that mindset that anything I say goes, you will find yourself in trouble. You will find yourself in constant conflict. But if you're able to manage the situation well, employees too know. In fact, once you manage your employees well, you may not even have any reason to even join any union in the first place. So that's something to keep in mind in dealing with unions. And that's my last thought on this issue. Thank you. I guess at this stage, I can then call for questions from the house. So, question time. How it works is this: if you, Kemi Kayode, I see you. How are you doing? So, how it works is this. I haven't seen anyone type any questions so far. So I will just unmute. If there's anybody who has questions, can you please indicate so that I can recognize you, and then you can ask your questions.
Okay, anyone?
Yes, Kami. Hi.
Coming.
Okay, Adetutu, you
Yes.
first.
Okay, so yes, my of information.
Hello.
Can you hear me?
Start again. Yes.
When you were talking about the collective bargaining agreement, you said that people who are privy to certain types of information should be exempted from the agreement.
Yes.
Can you hear me? Hello?
Hello.
Yeah, can you hear me?
Yes, I can.
Okay, so you said they should be exempted. So now my question is, how do you tell the union, or how do you tell a person that the person cannot join the union without breaching his rights? So he has a constitutional right to join this association or to be part of the union. You then say that, because you're privy to certain information, you cannot. I mean, because that's a challenge we face, where I try to put in the CBA that a certain category of people cannot join the union. and it was opposed by the union. The only people that the union allowed to be exempt in an agreement is the management staff. Anybody else,
Yeah.
irrespective of what you do, can join the union. That's the position. So, and the argument was that it's their constitutional right to join the union. So how do you balance that?
Okay, thank you. The union's position is actually what I said. I didn't say that you can decide to exempt anybody, I mean, just any random person from joining a union. What I said is that the law as it is prohibits management staff from belonging to a union. So what that means is that as an employer, if you have a management staff and the management staff on its own, for instance, says, I want to join a union, my recommendation to a client is always that that employee has an option. And the only option is to relinquish that position of a management staff. I am not saying that the person should be sacked, but what we're saying is that you cannot be a part of management.
And still be
a union member. That's what the law says. I hope that
No,
clarifies your, yeah.
James,
Yes, Tutu.
not a member of management, but the person is say the treasury in treasury, or because I know you use that example of someone who is privy to finance, finances of a company. So perhaps the person is in treasury, or the person is in HR, right? They're not at management level, but they're privy to confidential information of, or sensitive information, because I mean every information is confidential. So maybe sensitive information of the company. And that person wants to join the union. How does a company say you cannot join the union because of the information that you work with or that you're privy to?
Yes, that's a good question. But if you also recall, I also used that example. I said it doesn't matter, it's not a matter of the nomenclature or the title they put on your letter. And the example I used was that even the PA to the MD, because of the extra official duty she may be performing, may have access to more confidential information than the supposed head of HR. So my advice is, if you then have that person, hypothetical person in your situation, who is like a low-level staff, so to speak, but is in control of sensitive information, then the argument would fly that that person is a projection of management. Depending on, the factual situation you find yourself. So is it just someone who is a file keeper? If it's a file keeper, it's not a projection of management. But if he's in access, if he's in a position where he can influence decision making, then it's a projection of management. So in your own case, I think maybe the risk you run, which is probably the prism from which you're looking at it from, is that this person that knows where to get information for the union, how can we prevent him from joining the union? My answer to that, off the top of my head, I mean, you guys are free to disagree or share a better opinion, is that is not a union membership issue. That is more an issue of safeguarding of your confidential information. And how you do that is by having better risk management or data management processes in your organization. Of course, we expect that you would have non-disclosure and confidentiality agreements with all your employees, because the truth is, once you are in a premises, depending on how porous or not the organization is, anybody can access any information. You understand? But we are talking about people who will be in a position to advise management on what the position should be to a union demand, at the same time being beneficiaries of any decision that that same management makes at the end of the day. I hope that has taken care of your question.
Yes, it has. Thank you, Jamie.
Okay, thank you. Any other question?
Don't get money. That she don't.
Is there any other question?
Okay, that's about
Another question, Jamie. Sorry, I need to hear again. Hello, Jamie. Can you hear me?
Yes.
Oh, someone asking a question.
Yes, Tutu. Hello. Hello, Tutu. Hello.
Okay. Jamie, can you?
Yes, yes.
Hi, stop that.
Hello, can you hear me, Jamie?
Jamie
Yes,
can
I
hear
can.
you. Can all hear you?
Okay. So my question, my second question is, okay, I know typically you talk about a minimum membership of a union, but I can't. It's a bit loud, noisy. Okay, there's general knowledge that I mean it flies around that once a membership of a union is less than 10 or something, that you don't need to recognize them or you don't need to deal with them. What is the practice around that? So for instance, if people exit the union, you have just 5 people left or 10 people left, am I still compelled to have these meetings and empower them like they were 100 people? Is anything that because I think it's a waste of time and resources if I'm negotiating only for 5 people or 10 people. Is anything that allows you to restrict a union where their membership within a company falls below a certain number?
Okay. That's a good question. But if you ask me, I would say that there is nothing
In the labor laws that would permit that. Don't forget that what we said earlier is that when it comes to membership of trade unions, that the law has severely restricted the powers, so to speak, of the employer in um, refusing to recognize a trade union within its premises. I see that as more of a practical challenge for the company because what you're saying is, oh, I mean, I have just 5 people. Why should I be uh, put through the stress of signing a collective bargaining agreement? But if you ask me, I am not aware that a company can choose at what level or how many numbers of staff it's going to negotiate with. So technically, it's there's nothing to suggest that even if it's 3 or 4, 5 members, that you would refuse to negotiate with the union. And don't also forget that when it comes to um, number qualification under the Trade Unions Act, that is the number of people that can form a trade union, not the number, I mean, to bring a trade union to life. It is not the number of people within a premises that can go ahead to affiliate themselves to a trade union. I don't know if that makes sense. So for instance, Pengasan is um, a trade union that takes care of the interest of oil workers. And depending on the size of your oil company, you could have just one Pengasam member in your filling station, whereas in a Mobil or Chevron, you can have thousands of workers, hundreds of them belong to um to the same Pengasan. So, but I see your point, and I'm just saying it the way I understand it. If anyone else has any practical idea on how they approach it in practice, when they have just one or two or three members, how they approach that. What I think happens in practice is, I doubt if any union, in this country, everybody chases money. I doubt if any union will come to your premises if they have just one person to unionize. They don't have that time. They go for the big companies where um, they can find hundreds of people to unionize, because guess what? Their own interest is also pecuniary, because for each person they unionize, they get dues from the person. So why would they come and waste their time and effort signing collective agreement for 2, 3, 4 people? I'm sure they won't. Because don't forget that most times what happens is that it is the employees that invite unions to the premises. We are being oppressed here, will come and help us. And then you say, hey, how many of you are there? We are 3. We can't, we don't have your time. But when you are 100 and they calculate check off dues, maybe the average person in the company collects 500,000. Check off dues, 10,000 times 500 people. That's a lot of money. But we say you are a lone ranger, no union will even come to the premises. I mean, that's my own experience. I don't know if anybody has
A contrary opinion.
ọmọ yìí ayé ìgbà tí mo ti lọ mo ṣáà ti lọ ra nǹkan tí n bá fẹ́ ra nǹkan tí mo bá fẹ́ lọ
Hello.
ọjọ́ kan báyìí pé ìgbòho tó wà.
Any other person with a question? Okay. And on that note, I will thank everybody for
making time to be at this month's webinar. We'll continue
next month. Our webinars take place.
Sorry, last Friday of every month. The presentation will be shared to interested people by email. If you please send your requests to our email address, which is elannigeria@gmail.com. That's Elan, ELLAN, Nigeria@gmail.com. Thank you for your time, and have a great weekend and happy holidays.
Thank you,
Bye.
Jamiu.
Yeah.
Thank you very much, Jamiu. Bye.
Thank you, Jamiu. Bye-bye.
Nice one.
Well done.